The narrative begins not with dramatic confrontation, but with quiet restraint. What astonished those present in the courtroom was the absence of any explosive outburst. No raised voices, no dramatically slammed documents, no impassioned protests. Instead, a single, measured sentence emerged, delivered in a tone that was almost bureaucratic. "I don't recall." In a setting where every utterance is meticulously documented, preserved, and capable of being scrutinized years later, those understated words carried disproportionate weight, far exceeding any heated accusation hurled in public forums outside. This legal proceeding involving Prince Harry never truly centered on sensational tabloid drama in the conventional sense. He entered London's High Court portrayed as a determined figure challenging an entrenched system that had inflicted lasting harm, a royal son pitted against the formidable apparatus of the British media. The classic underdog tale, David facing Goliath. Yet here, David came equipped with formidable legal representation, personal protection, and a worldwide following predisposed to support his perspective. The core allegations appeared straightforward at first glance. Claims of improper and illegal methods used to gather private details, spanning many years, with accusations that certain powerful media entities had breached ethical and legal boundaries while vehemently denying any wrongdoing. Prince Harry contended that the publishers behind the Daily Mail and Mail on Sunday had either directly engaged in or arranged for unlawful practices to acquire confidential information concerning him and his relatives. These alleged methods included phone hacking, blagging, deceptive pretexting, physical surveillance, and a broader institutional environment that allegedly prized invasive reporting and sensationalism above all else in the race for attention-grabbing stories. The defendants countered forcefully, labeling such accusations as baseless and absurd. They maintained that their journalism adhered to responsible standards, relied on lawful sources, and involved articles from long ago that had never faced formal challenge in their immediate aftermath. They framed the claims as a retrospective rewriting of events, driven by lingering resentment rather than fresh facts. For much of the public, the dispute initially unfolded as a stark moral contest over journalistic integrity, two competing versions of events, each presented with conviction. However, as witness testimony commenced, a more understated yet profound transformation occurred. Courtrooms operate not on passion or popular opinion, but on verifiable records. Once Prince Harry stepped into the witness box, the focus subtly pivoted away from presumptive media misconduct toward a more rigorous examination. What precisely could be substantiated, what rested on supposition, and what was held with such conviction that it blurred into perceived fact. Importantly, Harry's demeanor during testimony did not suggest deceit. On the contrary, he frequently came across as genuinely earnest, even exposed, visibly frustrated, deeply hurt, and utterly convinced that profound wrongs had been committed against him. The specifics sometimes seemed less critical than the intensity of that conviction. Yet legal proceedings evaluate certainty differently from everyday human interactions. Courts remain indifferent to the depth of one's sense of violation. They demand concrete demonstrations of how, when, by whom, and with what supporting proof the violation took place. Tangible elements like records, timelines, admissions, or traceable documentation. Presiding Judge Matthew Nicklin exemplified calm authority, never resorting to theatrical interventions, reprimands, or overt displays of bias. He simply observed attentively, permitting responses to stand unaltered. This approach proved more impactful than any dramatic flourish, as it allowed the evidentiary record to reveal its own contours, which did not invariably match the anticipated storyline shaped by public sympathy. One understated exchange early on escaped widespread attention. No viral soundbite, no immediate pundit commentary, but it resonated deeply for those familiar with courtroom dynamics. When queried about the basis for asserting that particular articles stemmed from unlawful conduct, not merely suspected or inferred, but definitively known, Harry's explanations often drew from personal conviction, logical deduction, and the premise that harmful private revelations in print implied illicit acquisition methods. This reasoning feels intuitive to many. It aligns with common sense in the face of intrusion. Under sworn examination, however, such inferences prove fragile. The court proceeded without haste to rebut, instead posing successive, measured questions that steadily narrowed the divide between subjective perception and demonstrable reality. Did he possess first-hand awareness of phone hacking linked specifically to his situation? Was there concrete linkage between individual reporters and prohibited actions? Could he detail the precise acquisition methods? Or were conclusions reached primarily in retrospect? These inquiries avoided overt aggression. Their measured persistence carried greater potency. Patience in legal settings seldom signals indifference. It often indicates careful scrutiny. Gradually, an uneasy realization emerged. Much of the testimony rested on backward-looking reasoning. Because invasive material surfaced publicly, the process must have been invasive. Because comparable misconduct affected others, it presumably affected him similarly. Because unethical practices prevailed in one period, they must have tainted every related instance. This framework carries strong emotional appeal, yet it falters when subjected to strict evidentiary demands. Judge Nicklin refrained from vocal commentary, simply permitting the gap between feeling and proof to remain evident. When certain assertions were implicitly categorized as conjectural, a term deployed neutrally without emphasis, the implication was significant. Once labeled speculative, a claim's influence diminishes, altering subsequent interpretations without erasure. Judge Nicklin allowed this coexistence alongside denials, creating parallel versions within the official record. Consequently, the trial contracted inward. The more Harry elaborated, the more scrutiny fell on his own interpretive framework: recollection versus documentation, conviction versus corroboration, lived experience versus admissible evidence. This scrutiny did not vilify him, but rendered the position more vulnerable. Precarious claims rarely implode spectacularly. They often diminish gradually, almost courteously. By the conclusion of initial testimony phases, the atmosphere had transformed subtly, not through upheaval, but through clinical detachment, evaluation, measurement, anticipation. When a court begins assessing a claimant's reliability with the same rigor applied to the accused, the narrative irrevocably alters. The focus expands beyond alleged wrongdoing to encompass dependability, with doubts in reliability reverberating widely. By entering the witness box, Prince Harry did more than challenge his adversaries. He committed his memories, interpretations, and presumptions to an enduring, unalterable legal archive, one subject to endless citation, re-examination, and reframing in ways beyond any book or interview. As Judge Nicklin maintained his composed vigilance, it grew evident that, regardless of ultimate judgment, the act of testifying had already effected an irreversible realignment. Gravity shifted from the accused publications toward the testifying witness himself.